Hi, my name's Gemma Lee, student number 19501550. This is Property Law for Business, Assignment 2, Oral Presentation. Case background. Our client Anthony, a former recruitment manager, purchased a farm in southwestern Australia. He borrowed $500,000 from Magoo Finance to carry out capital works in creating a vineyard and secured the loan on the property by way of first mortgage. Anthony eventually became a successful winemaker and his property produced a famous Shiraz in 2021. However, not long after, when undertaking annual spraying of the vineyard, an overspraying occurred on adjoining farming properties, which caused considerable damage to neighbouring farm crops, which Anthony was liable for the damages of. He is therefore left in grave financial position and defaults on his mortgage with Magoo Finance. Some specific facts from his case include Magoo Finance have given Anthony notice under Section 106 of the Act and proceed with the mortgage's sale by auction. Magoo Finance appoints a friend of its managing director, Mel Turnbull, a real estate agent, to conduct the sale. The property is only advertised once in the Australian Financial Times, which was on Good Friday. The property is not advertised local or in any rural newspapers. The description of the property is not fully outlined regarding its actual usage as a vineyard, and the auction is attended by 3 people, of which it is sold to M&L Pty Ltd, a company of which Mel and his wife are the sole shareholders and directors of. And also, the purchase price is significantly below market valuation of the property. Anthony has come to us for advice regarding his rights as a mortgager, and in particular whether the sale to M&L Pty Ltd should be set aside. We note that in accordance to Section 113 of the TLA, the mortgagor is obliged to pay debt and interest owing on a loan. If these requirements are not met, then under Section 108 and Section 106, a power sale may be actioned, which in this instance is exactly what has occurred. However, certain requirements need to be met regarding the information mentioned, including sufficient advertisement, including both the description and places the property have been advertised, which in accordance to cases Pendlebury and also the ANZ Banking Group Ltd, these requirements have not been met. It is also important to note that the mortgagee needs to act in accordance to the best interests of both parties. These include to act in good faith without fraud and reckless behaviour according to the Siegel case. With regards to this case, there evidently states that the real estate agent Mel Turnbull, who is conducting the sale of the property, is a joint shareholder and director of M&L Pty Ltd with his wife, of whom the property is sold to in the auction. Therefore, this provides evidence towards the sale being made with a related party. This is not an act of good faith and is in fact a fraudulent act between the mortgagee and the real estate agent, or the buyer in this instance. Not only do we note that this sale was made to a related party, it was also sold at a price that was significantly below the market valuation of the property. Therefore, in conclusion, it would be advised to Anthony that a breach of good faith has been proceeded with and that the power of sale of the property was not exercised properly. He has 2 options. One would be to ask for the sale of the property to be considered at the evaluation of what it should be and he be compensated for the difference. Or I believe that Anthony should be able to challenge the power of sale to be set aside in accordance to the fraudulent activity that has been occurred in this instance. Thank you.